When planning for the future, many Atlanta residents consider how to manage their estates with efficiency and foresight. A living trust is a powerful tool in the estate planning arsenal that can help achieve these goals. In Georgia, a living trust is a powerful tool that allows you to manage your assets with precision and care, ensuring that your wishes are honored and your beneficiaries are cared for according to your exact specifications. What is a living trust and how does it work? A living trust, in legal terms, is a document that allows an individual, known as the grantor, to place assets into a trust for the benefit of beneficiaries, which can be managed by a trustee. This arrangement offers the flexibility to manage your assets during your lifetime and specifies how these assets will be distributed upon your death. The benefits of establishing a living trust in Georgia. Creating a living trust in Atlanta offers several advantages. One key benefit is avoiding the often lengthy and costly probate process. Assets held in a trust can be transferred to beneficiaries without probate, saving time and preserving privacy. Differences between revocable and irrevocable living trusts. A fundamental aspect to understand when considering a living trust in Georgia is the difference between a revocable and an irrevocable trust. A revocable living trust can be altered or dissolved by the grantor at any time during their lifetime. This flexibility allows the grantor to adjust the trust's terms as their circumstances or intentions change. Key terms and parties involved in a living trust. To navigate the complexities of a living trust, it's crucial to understand the key terms and parties involved. The grantor is the person who creates the trust and transfers assets into it. The trustee is the person or entity responsible for managing the trust according to its terms for the benefit of the beneficiaries, who are the individuals or entities entitled to receive assets from the trust. Seeking professional advice for your living trust. Creating a living trust is a significant step in managing your estate, and it's critical to ensure that it is done correctly to comply with Georgia law and accurately reflect your wishes. A skilled Atlanta estate planning attorney from Trace Brooks Law can provide invaluable advice and assistance throughout this process, helping to navigate complex legal requirements and tailor an estate plan to your unique circumstances. Consulting with an estate planning attorney is recommended in various situations to ensure your living trust is valid, effective, and aligns with your overall estate planning goals. Here are key moments when you should consider seeking legal advice. 1. Initial planning. 2. Asset analysis. 3. Complex family dynamics. 4. Navigating tax implications. 5. Updates and amendments. 6. Special types of trusts. 7. Trust administration guidance. 8. Legal challenges. Preliminary considerations before starting a living trust. Before you embark on the journey of creating a living trust in Atlanta, there are several preliminary steps you should consider. These steps are critical in forming a strong foundation for your estate plan and ensuring that your living trust aligns with your overall objectives and complies with the estate planning laws of Georgia. Assessing your estate planning goals. The first step in any estate planning process is to clarify what you want to achieve. Your goals may include ensuring that your heirs are provided for, minimizing the tax burden on your estate, avoiding probate, or maintaining privacy regarding your estate's distribution. Consider 1. Who are your intended beneficiaries? 2. What kind of legacy do you want to leave? 3. How do you want your assets to be managed during your lifetime and after your passing? 4. Do you have specific wishes regarding healthcare decisions and end-of-life care? Determining eligibility for a living trust in Georgia. Virtually anyone can establish a living trust in Georgia, but whether it's the best option depends on individual circumstances. In Georgia, living trusts are often used when 1. You have real estate or other significant assets. 2. You want to avoid the public process and costs associated with probate. 3. You seek to control the distribution of your assets over time, rather than a one-time distribution. The importance of a comprehensive asset inventory. Before setting up a living trust, it is crucial to perform a comprehensive asset inventory. This inventory will list all your assets, including real estate properties, bank accounts, investments, and personal property of value, like art or jewelry. The asset inventory should 1. Identify all assets that can and should be placed in the trust. 2. Evaluate which assets may require special consideration, such as business interests or out-of-state property. 3. Establish the value of your assets to assist in tax planning and distribution decisions. Deciding between a single versus joint living trust. In Georgia, you have the option to create a single living trust or a joint living trust. Generally, separate trusts are preferable even for married couples. Separate trusts, often with the same dispositive terms, sometimes called mirror trusts, offer easier administration and, in limited circumstances, creditor protection. The decision between a single or joint trust can be influenced by many factors. 1. Marital status. 2. Separate property. 3. Estate tax planning. Choosing the right type of living trust for your needs. When it comes to estate planning in Atlanta, Georgia, selecting the appropriate type of living trust is pivotal to meeting your financial and personal goals. Georgia law provides for various trust structures, each with its own set of advantages and drawbacks. Understanding these can help you make informed decisions that reflect your intentions and provide for your beneficiaries in the most effective way possible. Analyzing the pros and cons of different trust structures. In Georgia, the two primary types of living trusts are revocable and irrevocable, and each serves different purposes. Revocable living trusts. 1. Pros. Can be altered or revoked at any time during the grantor's lifetime, providing flexibility. 1. They also allow for the seamless transfer of assets after death, avoiding the probate process. 2. Cons. Do not offer protection against creditors during the grantor's lifetime and are not a tool for reducing estate taxes. Irrevocable living trusts. 1. Pros. Once assets are transferred into an irrevocable trust, they are generally protected from creditors and may not be subject to estate taxes upon the grantor's death. 2. Cons. The grantor relinquishes control over the assets once they are placed in the trust, as these trusts cannot be altered without the consent of the beneficiaries. Tailoring the trust to your specific family situation. Your family dynamics play a significant role in deciding the type of trust that is most appropriate for your estate plan. Consider the following. 1. Marital status. 2. Blended families. 3. Special needs dependents. 4. Minor children. The role of a living trust in tax planning. While Georgia does not impose its own estate tax, Atlanta residents must still consider federal estate taxes when creating a living trust. Here's how a living trust can play a role in tax planning. 1. Revocable trusts. These generally do not provide tax benefits, as the grantor maintains control over the trust assets. 1. The assets in the trust at the time of the grantor's death are considered part of the taxable estate for federal tax purposes. 2. Irrevocable trusts. Because the grantor relinquishes control of the assets, these trusts can be used to minimize estate taxes. 2. Assets placed in an irrevocable trust are usually not considered part of the grantor's taxable estate, potentially leading to significant tax savings. Step-by-step guide to creating a living trust in Georgia. Creating a living trust in Georgia involves a series of steps that are designed to ensure that your estate is managed and distributed according to your wishes upon your death or incapacitation. Here's a step-by-step guide tailored to the laws and regulations of Atlanta, Georgia. Documenting your decisions. Drafting the trust agreement. 1. Determine the type of trust. 2. List your assets. 3. Identify your beneficiaries. 4. Draft the trust document. Selecting a trustee and successor trustee. 1. Choose a trustee. 2. Select a successor trustee. 3. Define trustee powers. Property titling. Transferring assets into the trust. 1. Create a schedule of assets. 2. Transfer title of assets. For each asset, you would need the title to reflect the name of the trust as the new owner. 2. This process varies depending on the type of asset. 3. For real estate, a new deed transferring ownership to the trust must be executed and recorded with the county recorder's office. 4. For bank and investment accounts, contact financial institutions to retitle accounts in the name of the trust. 5. For personal property without formal titles, you can assign ownership to the trust within the trust document or through a separate assignment of property form. Notarization and witnesses. Finalizing the trust legally. 1. Sign the trust agreement. 2. Store the trust document. 3. Register the trust. 4. Review and update as necessary. Navigating challenges and common missteps. Estate planning involves a series of detailed and sometimes complex steps, especially when creating and managing a living trust. There are common pitfalls that can complicate the estate planning process. By being aware of these challenges and how to navigate them, you can ensure that your living trust is effective and serves its intended purpose. Avoiding pitfalls when funding your trust. One of the most common mistakes in the creation of a living trust is failing to properly fund it. Funding your trust refers to the process of transferring your assets into the trust. Here's how to avoid the pitfalls. 1. Complete all necessary transfers. 2. Maintain accurate records. 3. Regularly review beneficiary designations. 4. Consult professionals. Updating your living trust. When and how. A living trust is not a static document. It should be reviewed and updated regularly to reflect changes in your life circumstances. Here's when and how to update your living trust. 1. Major life events. 2. Legal changes. 3. Periodic reviews. 4. Execute amendments properly. Connect with Trace Brooks Law by calling 404-492-9559 today.